Good morning, Your Worship. Thank you, Your Worship. Case number 3246 of 2018. Today being the State visit to Duduzane Zuma. Today being the 29th day of March 2019. The appearances as before. The matter was adjourned this morning for a ruling on an application for a section 174 discharge. Thank you.
As indicated by the power for the prosecution, it's a ruling on an application in terms of the provision by section 174 of the Criminal Procedure Act, 177 is amended from time to time. The accused, Mr. Duduzane Zuma, before court is charged with one count of culpable homicide arising from a driving of a motor vehicle and the alternative count of contravening the provisions of section 63 subsection 1 read with sections 1, section 63 subsection 2 and subsection 3, section 69, section 73 and section 89 of the Road Traffic Act number 93 of 1996, negligent driving. The accused pleaded not guilty to both the main and the alternative counts. He tendered a comprehensive explanation in terms of the provisions of Section 115 of the Criminal Procedure Act and also made admissions in terms of Section 20 of the same Act, 220 of the same Act. This led to the narrowing of issues between the state and the defense. The issue of negligence was pertinently put to the state to prove. There are common cause facts which this court has found, and the following facts were established as common cause facts through the admissions made by the accused, Mr. Zuma, as well as evidence which was led on behalf of the state. It is common cause that the incident happened on the 1st of February 2014 at around 2200 hours. That the collision happened between the vehicle Porsche 911 with registration ZYP513GP, driven by the accused Mr. Duduzane Zuma, and a Toyota Hi-Ace minibus bearing registration number NWP376GP, driven by Mr. Dlamini, who testified as the second witness before this court. It is also common cause that the minibus operated as a taxi, and on that day had a full complement of 14 passengers. That the collision between the two vehicles happened on the M1 South near Greyston on-ramp. That as a result of the collision, both the two vehicles that as a result of the collision between the two vehicles, there were injuries sustained by some of the passengers, and there was also a fatality in that one Ms. Pumzile Dube lost her life. Another passenger later lost her life in hospital. The name of the deceased was Lynette Mashaba. Her death was subsequently attributed to natural causes. It is also common cause there were also other passenger namely Charlotte Ndlangiza, who sustained injuries. She testified in this court as a witness number 5 for the prosecution. There had been a period of sustained rainfall. It is also common cause that there had been a rain of sustained rainfall which resulted in the water running across the highway. There were periods when it rained moderately and periods when it rained heavily. As a result, there was reduced visibility. As indicated above, the accused tendered a detailed plea explanation which in essence amounted to the fact that an incident of aquaplaning stroke hydroplaning as a result of his vehicle hitting a puddle or a pool of water. He stated in his plea explanation that he lost control and this led to a collision with the minibus. The state led evidence of 6 witnesses, and this included Mr. Zuma, who testified about the climatologist who testified about the rainfall measurement which was recorded during the period from a station in Alexander. There was also the evidence of Mr. Kronje, the principal dealer at Porsche, Johannesburg. He testified, among other things, about the service history of the vehicle, the Porsche vehicle, during the period in question, or around the period in question. The state also called Mr. Dlamini, who was the driver of the minibus. The 2 passengers in the vehicle, namely Ms. Metro Mdakani and Ms. Ndangiza, were also called, and they both testified. The last witness for the state was Mr. van Randburg, and thereafter the state closed its case. As a result, this application. The defense then launched the present application that the court should, in terms of Section 174 of this Criminal Procedure Act, discharge the accused. The argument being that at this stage of the proceedings, there is no prima facie evidence upon which a reasonable court can convict. Now, what does the law say regarding Section 174 discharge? The correct interpretation of Section 174 of the Criminal Procedure Act was laid down in the case of R vs. Say, 1925 AD 6 decision, and has been applied since. This interpretation requires that the court should order the discharge of an accused person where it is of the view that there is no evidence of his or her having committed the offense in the charge sheet, or any other offense which may arise in terms of a competent verdict. Section 174 of the Criminal Procedure Act provides for an accused to be discharged at the close of the prosecution's case if the court is of the opinion that there is no evidence that he or she committed the offense referred to in the charge, or any other offense of which he or she may be convicted in terms of the charge. In such circumstance, a court may return a verdict of not guilty. This requires that the court evaluate the evidence at the close of the prosecution's case differently from how that evidence will be evaluated at the end of the trial, and this is an emphasis. This is because a discharge in terms of Section 174 of the Criminal Procedure Act is a sui generis interlocutory procedure. That is, a question of law is determined and not a question of fact. And it is also for this reason that in case where assessors are involved, they are prohibited from participating in rulings in terms of Section 174 of the Criminal Procedure, in case where the assessors are used. The test for a discharge under Section 174, and I emphasize, differs from that at the end of the case where the court is required to assess the evidence as a whole, including the probabilities of the particular case. The test to determine whether there is indeed no evidence upon which a reasonable court acting carefully would convict was articulated in State versus Shopping and others, 1983, Volume 2, SA 112, brackets B, where the first consideration, where it was stated the first consideration is whether there is evidence on which a reasonable person may convict. If the answer is yes, a discharge should be refused. If the answer is no, it must be asked whether there is a reasonable possibility that the evidence might supplement the state case. With regard to the second leg of the test, it was further held in State versus Lubaka 2001, Volume 2, CR 702, in bracket SCA, that a minimum of evidence was required for a person to be convicted. In the absence of such minimum evidence, a person ought not to be prosecuted merely on the expectation that at some stage he or she might incriminate him or herself or supplement the state's case. However, this minimum of evidence cannot be equated with a standard of proof, that is, whether it is beyond a reasonable doubt or on a balance of probabilities. The test, as indicated above, is sui generis and must be applied with judicial discretion in the light of specific facts and circumstances of each case. Judge Operman for the Free State High Court, Bloemfontein, in State versus M, an unreported case 2/2016, delivered on the 18 March 2016, described the test as a combination of the first test of Shuping case, the dictum in Lubaka case, and the principles of a fair trial in terms of the Constitution of the Republic of South Africa. In applying the principles of Section 174 of the Criminal Procedure Act, the following consideration must be taken into account. This is as per the State versus Kozo, where 1994-1 BCLRS 10 CK, in bracket CK. And these considerations are the following. An innocent person must, as far as possible, never be convicted of a crime. The conviction of a guilty person must be obtained with the best possible endeavors. The prosecution presenting the community must fulfill their duties within the framework of the law and the available facts. The right to remain silent and the satisfaction of the responsibility which is on the state must be satisfied as far as possible. And the rights of the accused are very important. The right of the community to see that justice is done is equally important. To achieve these goals, instruments should be used in such a way that justice is done to everybody. End quote. With regard to whether the credibility of state witness, which point was argued before this court by the defense, ought to be taken into consideration in deciding whether to grant a discharge or not, it was held that this should play only a limited role and that the evidence should be ignored only if it was of such poor quality that no reasonable person could possibly accept it. In the case of State versus Mpeta and others, 1983, volume 4, SA 262, in bracket C, Williamson J. as he then was, after analyzing the various decisions, concluded, and I quote, "However, it must be remembered that it is only in a very limited role that can be played by credibility at this stage of the proceedings. If a witness gives evidence which is relevant to the charges being considered by the court, then that evidence can only be ignored if it is of such poor quality that no reasonable person could possibly accept it. This will really only be in the most exceptional cases where the credibility of a witness is so utterly destroyed that no part of his material evidence can possibly be believed. Before credibility can play a role at all, it is a very high degree of an untrustworthiness that has to be shown. It must not be overlooked that the triers of facts are entitled, while rejecting one portion of the sworn statement of a witness, to accept another portion. Any lesser test than the very high one which in my judgment is demanded will run counter to both principle and the requirements of Section 174 of the Criminal Procedure. Thus, credibility will only play a very limited role, and the evidence could be ignored only if it was of such poor quality that no reasonable person could possibly accept it. This view is preferable to the one expressed in the matter of State versus Dadla, as it would prevent hopeless cases from continuing with the attendant expense, anxiety, and frustration to accused, while preserving the majority of cases for decision by the trier of facts. Where the uncontradicted evidence for the state is circumstantial and more than one reasonable inference may be drawn, a discharge should be refused. This is according to State versus Osteli, 1977, volume 2, SA 102, in bracket D, and also the State versus Paul Rollis, 1993, volume 4, SA 75, in bracket W. In the case of State versus Swartz, 2001, volume 1, SACR 334W, it was stated that when assessing the quality of evidence, this was not to be done in a vacuum. Credibility of an witness in an application for discharge was but one of the features to which a court could have regard. In the matter of State versus Zuma, 2006, volume 1, SACR 191W, in bracket W, the court stated that when dealing with an application for a discharge of the accused at the conclusion of the state's case, the complainant's evidence, as stated in the short judgment, was not so broken down that it could be disregarded. After referring to certain other evidence and the fact that reference was made to false charges, the judge found that those to be mere suggestions at that stage, and discharge was refused. Judge Salman J. also stated in State versus Moringa that the decision as to whether or not to refuse or grant a discharge at that stage of a trial was a matter solely for the discretion of the presiding judge officer. It should be emphasized that the discretion must be judicially exercised. This should also include the interest of justice. This court has been referred to another decision of the High Court, which also expresses the view that a discharge at this stage is discretionary, albeit such discretion must be exercised judicially. The case is Adlioti decision, where the judge remarked in terms of Section 174, there is no obligation to discharge, but a competence to do so. The court is called upon to act judicially with a sound judgment in the interest of justice. The court has before it evidence that has been referred to at the commencement of this judgment. Given the conclusion that I have reached, it suffices to state that such evidence has not been, in the words of William J., and I quote, such poor quality that no reasonable person could possibly accept it, end quote. I have exercised my discretion and that do not deem it necessary to deal with the evidence in detail. In considering this application for discharge of the accused in this matter, these considerations that I have referred to above and the test as described, the court concludes that there is evidence upon which a court acting reasonably can convict. I don't deem it necessary to deal at any length with the evidence and to pass at this stage. In the premises, application for a discharge in terms of Section 174 of the Criminal Procedure Act is hereby refused. Thank you.
As a conclusion, Your Worship, before the commencement of the proceedings, this is a interim measure, Your Worship. Myself and the defense did look at possible dates for the continuation of the matter based on whatever ruling the court was going to make, Your Worship. And we are requesting if the matter can be adjourned now for a defense case to the 15th, 16th, and 17th of May. So continue for the defense case. My learned colleague will address for the
Yes, Mr. Highlands?
Yes, Your Worship. We considered that given the number of witnesses we intend calling, it would be appropriate to set the matter down so that we can run it as we ran it up until Thursday, continuously and smoothly without interruptions by adjournments of any length of time. So we put our diaries together and came up with those dates, 15, 16, and 17. We trust that would suit you.
May 2019. Dates have been agreed with your defense team. You are want to be at court on that day. Unfortunately, the court, for which court will be determined, and it will be communicated to
Your Worship, may I request we keep it in this court? I will make
Okay.
all the other necessary arrangements.
Thank you.
Yes, if you make it this court and then we change it on the day, that would be fine. At least there's a point of
There's
departure.
a point of departure, yes. Yeah, you are want to appear in court number 13, 8:30, on the 6th, 15th, and be available for other 2 dates, 16 and 17. Thank you. You may step down.
And court, please, Your Worship, may I request that you adjourn at this particular juncture?
Thank you. Overdag.
Thank you, people. All right, thank you.